Hi, we're back with the lecture for week 3. As I've stated previously, these lectures are not intended to replace the other materials, the book and the other assignments. This is to supplement that. And so the material here is in addition to what is in the book, and you need to understand both the material in the book and the other assignments as well as the lecture. What we're going to talk about today is employee agreements and employee handbooks and the need for those, and when you need them and when you don't need them, and how to properly prepare handbooks and what to include and not include in the handbook. The first thing that I want to discuss is employment agreements and when you should consider an employment agreement and when you should not. Under that employment concept, most employees in the United States do not have employment agreements. If you look outside the United States, it's real traditional for almost everyone to have an employment agreement. In certain jurisdictions, like London or England, they would all pretty much have employment agreements. In other countries, but in the United States, under American law, most employees are not under an employment agreement unless they're a high-level employee, some type of executive, and those relationships usually require some kind of employment agreement because of the negotiating power of the executive. There are other times where you may want an employment agreement with respect to protecting confidentiality and the confidential information and trade secrets of the employer, as well as non-compete situations, and we'll address both of those briefly. Key terms, if you're going to have an employment agreement, is what is the salary, what termination provisions are going to be there, and that really is, are you going to keep at-will employment as a term of the contract, or are you going to take it out of at-will employment and give some type of termination only for cause? The employer can only terminate for cause, and if they don't terminate for cause, there usually is some kind of monetary payment that would be due to the employee. Now that can be tied to a separation and release agreement as a term and condition to get that severance money if someone is terminated without cause. Another provision that's typically and should always be in there is a confidentiality provision. And that protects the employee from taking and using the confidential information for purposes after they leave, as well as while they're there for some non-employer purpose for that company. And that provision should also include something that requires the employee to return the confidential information at the request of the employer or at the time of termination at the end of the relationship. Non-competition provisions, we'll hit on that in a few minutes. If there's a bonus, what would the bonus be, and what would be the conditions under which the bonus is paid, and when is it earned? And then also, what happens upon termination? Do they get the bonus or not? Even if part of the time period over which the bonus is intended to cover has already happened, do they get a prorated portion or not? And those would be terms that you would include in the employment agreement, as long as in the employment agreement. Also, severance pay, if you're going to be entitled to severance pay, if you're terminated without cause, or some other provision that would trigger severance pay, like a change of control with the management of the company. And what are the conditions surrounding the severance pay? Will it be paid just outright, or will they have to sign a release of claims to get it? On the common mistakes, here's common mistakes that we see in employment agreements. And under too many restrictions on the company, the idea in an employment agreement is to limit the restrictions on the company and typically put the company restrictions on the employee. Termination for cause, sometimes it's too narrow to be helpful for the employer to actually terminate someone. If the definition of for cause doesn't include many things, then the employer will not be able to terminate for cause and will be usually subject to paying the salary for the remainder of term of the employment agreement. Notice before termination, there's a lot employees would want to negotiate into a contract a narrow cause definition, as well as before an employer actually terminates for cause, that they be given notice and an opportunity to cure and correct before a termination occurs. Companies would want to eliminate that provisions. Employees would want that provision. And then flexibility in to whom the person reports. An at-will employee, a company can change the terms and conditions of employment at any time with notice. And if the employee doesn't like it, they can leave. Once you're bound to an employment contract, if you have a reporting structure or what you say their duties are, then you're going to be limited to make changes unless you have the agreement of the employee to do so. And so you need to work on that and really think about what you put into the employment agreement in that regard. Lack of clarity as to bonuses creates a lot of breach of contract claims under this context, so that needs to be specified, as well as commission agreements, commission plans. There should be restrictions on the employee with respect to fiduciary duties, and that they should be required to follow the directives of the company and their supervisors. And then you should tie all severance payments to the actual to a release of claims. Another thing that you often see is what happens when the term ends. Does it renew? Does it renew for like terms? How does that go? And if you have a non-renewal provision, then at the end of the term they can become an at-will employment, but that needs to be spelled out in the employment agreement. Non-compete agreements, they are negotiable. The FTC is currently pretty hostile towards non-competes. Certain states like California have said they are unenforceable and will not be enforced in that state, but in Texas they're enforceable. And you should not assume that when you're entering into a non-compete with a Texas employer that it's not enforceable, even though a lot of people will say that. And they don't know what they're talking about, and while courts don't love to enforce them, they definitely will. Lots of other states where they haven't outlawed non-competes altogether, such as California, have put in restrictions over the last couple of years that said a non-compete is only going to be allowed if you're a high wage earner, and that the low wage earners can't be subject to non-competes. What constitutes a high wage earner or a low wage earner is going to be different with respect to each state. And so you'd have to look into that if you were trying to have non-competes on behalf of a company in different states, because each state's law will control when that agreement is allowed and what can be the restrictions and parameters associated with that. In Texas, they are enforceable. They generally require three things: that they're reasonable in time, geographic area, and scope of activity to be restrained. So what does that mean? If you leave the company, you can't compete with the company for 1 year within these three counties, and the activity to be restrained is similar to what services you perform to the company. If you try to do a longer period of time, let's say 5 or 10 years, the court will typically say that that's unenforceable as a matter of law. It has to be tied to the information that you're trying to protect. The geographic area should be tied to the area in which the employee actually performs services for the company. And that's why the scope of activity would need to be the same as kind of the scope of activity that they perform for the company. The consideration for a non-compete in Texas has to be confidential information or specialized training or some type of equity into the business. You cannot just buy a non-compete, meaning you can't just pay someone $5,000 in exchange for a non-compete. It has to be in exchange for providing confidential or trade secret information, specialized training, or some type of equity in the company. And the restrictions of the non-compete, we've kind of already referenced those. About it has to be restrained with respect to time, geographic area, and scope. And if it is too broad in those regard, then the court will not enforce it. And depending on which state, they may or may not revise and reform the contract to make it enforceable. Some will say if it's overbroad, it's just going to be found to be unenforceable completely. Other states, such as Texas, will revise it and reform it to what the court thinks is reasonable. However, that can limit some of the contractual damages that can be associated for a breach of the agreement. And moving on to employee handbooks. Handbooks can provide defenses to companies when employees try to sue for certain wrongful termination situations. And what they'll try to argue is that the employment contract creates some kind of contractual right. And so the idea with an employee handbook is to ensure that it is not a contract and is not going to be held as a contract, because if it is, then a company can be held to be in breach of that contract and will possibly not be allowed to terminate the employee or because they haven't complied with the contract. The goal with the contract in this is, from a company's perspective, is to eliminate the responsibilities and duties placed on the employer with respect to the employee handbook. And that's what that second bullet point is talking about. Be careful about restricting the company unnecessarily. You don't want to put too many restrictions. An example would be if in the handbook you said we do annual reviews for employees. And then if you forget to do a review or it falls through the cracks with respect to one employee, and if that's held to be a contract and you didn't provide an annual review, you could be in breach of that contract. So better language to be in there, not to restrict the employer, is to say something like, we typically do reviews on an annual basis for employees, or we do them from time to time would probably be better language. And if you desire one, you need to request in writing a review. And so if an employee later comes in and says, well, I didn't get a review as often as I like, the employer can go back and say, well, did you request in writing that you wanted one? And the answer typically will be they did not. And so you can push the burden back to them because they did not request it. And that would be the type of language you could use to not unnecessarily restrict the company. Some laws require specific notices to be in handbooks, like the Family Medical Leave Act. And if you've ever looked at your Family Medical Leave Act policy in a handbook, it's typically relatively long, and that's because there are so many requirements that are required to be in there as a matter of law, according to the Family Medical Leave and their regulations. So that would be things to include in handbooks. States typically have different laws and requirements. So oftentimes if you have a handbook that is going to be used in different states, you'll have to have supplemental provisions or have basically statements unless something to the effect of, unless otherwise required by state law, and then have your policy or procedure. The most important thing to have in a handbook is some kind of disclaimer, and to have it on the front page that this is not a contract. It's not intended to be a contract. These are policy procedures, and the company reserves the right to modify and change these policies and to enforce them in the best manner in which they see fit, and that they can do this at any time they desire. And if you have that kind of language, it's hard for an employee to come in and say that this is some kind of contract and provided them some kind of contractual right with respect. All right, now we're going to talk about state-specific policy issues. If you're a multi-state employer, you need to check out the state law, because some of those laws will require certain things to be in handbooks or not. Not all of these things are required to be in handbooks, but if you do have them and there's a specific state law, a lot of these items that are on this slide would be something you may want to include or required to include if the state requires you to do so. For instance, this first one, in Texas, there are no requirements for certain meal breaks and rest periods throughout the day. And so there really is no need to have that in the handbook. If you put it in the handbook, you could be limiting yourself if you later want to change it. So you could put something in there. Meal breaks and rest breaks will be directed by your supervisor, and then just kind of leave it to the supervisor to how they handle that versus being specific. To contrast that, California requires specific meal breaks and rest periods throughout the day, and because they're so specific and they're required by statute, lots of companies would decide to go ahead and put that into the policy itself, so that employees will know what the rules are, and so will their managers and supervisors as they implement those rules. The Family Medical Leave Act, we talked about a minute ago as something that that there are certain notices that you have to put into the handbook, and so would be other leave requirements. If you have short-term disability leave, STD, or long-term disability leave, or some kind of bereavement leave after a death in the family, there are laws with respect to that in most states. Like Texas, if someone dies, they're entitled to 3 days off to attend a funeral of a family member. And so you can go through and add things to the handbook with respect to different leave requirements, employees that you're going to provide your employees. Additional protected classes. If the state has additional protected classes that we talked about, I think it was in week 2, you would like to add those into your discrimination and harassment policies. You would always want to have a discrimination and harassment policy in a handbook, and a procedural mechanism on how to complain and report harassment. And that procedure would also need to have some kind of policy or procedure. If the person to whom they're supposed to report is the harasser, you need to make sure there's an alternative method of reporting for employees to have a proper policy. With respect to such a policy there, when we talked about harassment and there was a defense, and one of the defenses is that you have a harassment policy and that you train on it. And so you would want to have that in there. You would also want to have associated with that policy some kind of anti-retaliation, that if you complain about this, you will not be retaliated from complaining and asserting a right under the harassment or discrimination policy. And that is very important to have in a handbook. Forfeiture and accrual of vacation. How is your vacation policy or PTO going to accrue, and what will happen to that PTO when they leave? That would be something that would be typically in a handbook. And if you in Texas, you could put in the handbook accrued but unused PTO, or accrued but unused vacation is lost upon separation. If you have that in there, then there's no right to be paid out that. other states like California, once you accrue it, it has to be paid out on termination. So that needs to be looked at and put into a handbook appropriately. Drug testing requirements, those are usually state by state. We'll be talking about those in another week or two, and so we will address those later. But if there are particular drug testing requirements, that's typically the type of thing that would be in the handbook. Timing of when you're going to get your paycheck. That's usually a required notice that has to be provided to employees. You have to tell them when they're going to be paid. Is it every week? Is it bi-weekly, or is it going to be semi-monthly? But you have to put the pay days in there, and oftentimes you'll see that it'll be paid, on the 15th and the last day of the month, or something like that. If you're going to have deductions from paychecks, those should be very limited, if at all. And typically, you're required to have a signed written authorization from an employee to deduct from the paycheck. And so, be careful just doing that, and if you're going to talk about that, it would need to be typically in a handbook, and then also have an additional sign writing. Employee searches, what is that? That's dealing with privacy rights of the employee. And can you search their email? Can you search a phone that they're using and using for texting purposes on behalf of work? The answer is yes, but you will have to let them know this and beforehand. And if you say, look, you have no expectation of privacy with respect to the use of our computer systems or our phone systems or our email systems or any text that you're doing on your phone for work purposes, then you would have a right to search those and review those without any worry that you're violating their privacy rights. So typically that kind of stuff would be in the handbook. Another thing on searches, if you're going to search their desk or those things, you say you have no right of expectation of privacy with respect to those areas when you come into the workforce. And in fact, some people will say you have no expectation of privacy with any bags or things that you bring in, so they can also search your backpacks or your purses or things like that. And as long as you provide them notice of that, then you have the ability as the company to search, and that would typically be found in a handbook. There's also rules if you're going to, typically states will have laws on whether you can carry guns or not. Most in Texas, you cannot bring a gun in the workplace if the company has a policy on it. So if the company has a policy that says you can't bring a gun, and they post it in their handbook in certain ways, then you would be prohibited from doing that. You can have guns in your car on company property. That's in Texas you can, but you cannot bring them in the workplace. Now that's a private car. If it's a company car, they would be able to exclude any firearms from that. And then marijuana and CBD use, that is a state law issue. And the restrictions on that, typically people would put something in the handbook to kind of say how that will and will not be treated. So the most important thing on employment contracts is, do you have one or not? Most people don't. You usually have to be a high-level executive to get one. And if you do, the issues to really concern yourself is, what is the term of the agreement? What's going to happen to the bonuses and commissions upon termination, and what are your rights as the employer to terminate? And when you do, what pay will they be entitled to? What will the employee be entitled to? And will they have to sign some kind of severance agreement, or a release agreement to get that money? And as to handbooks, the biggest thing on handbooks is a disclaimer that they're not contracts, and to limit obligations on the employer, and don't promise too much on behalf of the employer that you're not required to promise, because you don't want arguments that you created some expectation that they're entitled to that, and have them argue that there's some kind of contractual restriction on the company to have provided it. So hopefully this lecture has been helpful, and please pay attention to the textbook and the other assignments associated with this chapter. Thank you.